Today is April 4th, 2011. We're going to begin Learning Module 5, and we will get into Learning Module 6 this afternoon. Learning Module 4 is about investigative interviewing regarding child maltreatment. You know, in the late 1970s and early 1980s, when American society and prosecutors' offices began to treat child abuse as a crime and rather than as a family matter, there were a number of issues that arose in investigative interviewing. Now, they didn't manifest themselves until some years later when these cases wound their way through the court system. But in the very beginning, when prosecutors began charging cases of child abuse, and more specifically child sexual abuse, the defense lawyers had a dilemma. They had some difficulty in developing a strategy to defend these cases, because the way they were used to defending criminal prosecutions and the way they were used to challenging the veracity or believability or truthfulness of witnesses was through the art of effective, passionate, assertive cross-examination. Their dilemma arose because the person who they needed to cross-examine in this new class of cases within the criminal justice system, the person whose veracity they needed to challenge, the person who they needed to get in their face and to imply, suggest, directly state was lying, manufacturing, fabricating, was a child. And they knew that that wouldn't play well to who? The jury. That would be suicide to challenge aggressively a small child, an 8 or 9 or 10-year-old on the witness stand. Yet they did not know any other way, so they had this dilemma. They didn't know quite how to defend these cases. Their focus, as always, was on the witness and the victim. And in this case, the victims, by definition, are children. Whether they are victims of a battering or child sexual molestation, they will eventually take the stand, and the defense lawyer has to challenge them in some way. They are the star witnesses in all of these cases. And they didn't know quite how to do that. And they fumbled along, and they pulled a few cases out of the fire once in a while, but they found these cases very challenging. And then we began to learn that the investigators, the persons who investigated these crimes, whether they were child protection or law enforcement or medicine or whoever, the persons who questioned children were not questioning children in a way that was optimum, ideal. And as I said earlier, these cases began to mature in the appellate courts maybe 5 to 10 years later. And those of you who took forensic interviewing know the group of cases that changed the legal landscape. They included the New Jersey case of State versus Kelly Michaels, and of course the California case of People versus McMartin. And then in North Carolina, there was a case involving a daycare center called the Little Rascals Daycare Center. And there was the Fell Acres Daycare Center. There was the daycare center in Jordan, Minnesota. There were lots of these institutional abuse cases where the behavior, where the strategies of the interviewers were called into question by the appellate courts and highly scrutinized. And many of these cases wound up being reversals, or the prosecution simply dropped the charges. And bad interview practice was exposed. So now the defense lawyers had something to hang their hat on. They had a way to defend these cases, and defend these cases vigorously, consistent with the way that they practice law, and that is assertive challenges to the truth-telling and the competence of the witness. They had a way to do this now without attacking the child. Because they could attack the detectives and the child protection workers and the medical professionals and the other folks who interviewed the children, who gathered the information from the children. And they did not have to get mean and nasty and in the face of the children. They did not have to suggest that the child was lying. To the contrary, the child was misled. Oh, you will hear Gabriella walk into court, ladies and gentlemen. She'll take that witness stand, and she'll say some things that polite people don't talk about. And she'll say them perhaps rather convincingly. You want to believe her, you may want to embrace her, you may want to take her home and hug her and make her safe. But none of it ever happened. The reason why little 8-year-old Gabriella is saying these things today, and said them 6 months ago when she went to the prosecutor's office, and said them 6 months and a week ago when she went to the DIFUS office, or DIFUS came to her school, is because the prosecutor's detective asked bad questions. So many bad questions that he turned her mind around and influenced her to believe that she's been sexually abused, when in fact none of it ever happened. So now the defense could say that the child's okay, she didn't do anything wrong, she's not a bad kid. They could even say she has all of the outward indicia, all of the indicators of believability. Right? She's believable. And when a witness who is a victim in a criminal case is believable, you don't need much more. If the jury believes the victim, it's nice to have corroboration, but you don't need much more. If they retire to that jury room and they say, I believe her 100%, she's very persuasive, he's very persuasive, I believe that it happened. That's the end of the inquiry. Guilty. Here, you can believe that the child's making statements that the child believes are true. The jury can accept that the child is not lying. Nevertheless, the defendant could be innocent. So the defense has a beautiful way to defend these cases without attacking the child. Attack the investigation. Attack the investigation. And they do. And they did. And they will. The good news is, from these cases, from this group of cases that arose in the late 80s, early 90s, that I just mentioned a moment ago, from this new defense strategy in attacking the interviewers and the detectives and the investigators and the child protection workers, from all of that explosiveness, I guess, from all of that blowback, if you will, from the late 80s, early 90s, child protection workers and prosecutors and child advocates began to reevaluate how we interview kids. And we said, you know what, we need to learn how to do this better. We can't make these mistakes again. We have to do better interviews. So it is a great day when that child comes in and testifies persuasively and believably and tells the story of what happened to her. And an even greater day when the detective takes the stand, or the child protection worker takes the stand, or the medical professional, or all three of them take the stand, and are able to communicate a competent investigative interview. They're able to defend themselves against the argument, the suggestions, and implications that they were misleading or suggestive or did an inept interview. To learn how to interview kids well is the perfect antidote to the defense attacks in child sexual abuse cases. Now, do we win every case? Do all DAGs win cases in front of judges? Do all prosecutors win cases in front of juries? No. But the two most important aspects of the case are within our control: preparing the child and doing a good investigative interview and a good investigation. Sometimes you don't have good facts. Sometimes the child has difficulty expressing themselves. They're so traumatized, their personality is such that they're not sympathetic for a variety of reasons, especially if they're adolescents. And with adolescents come all kinds of baggage. We've mentioned it in the past, and you know what they are. But we need to make the best possible presentation possible. Redundant there. And the way to do that is to make sure your kid's prepared, and make sure that your team and your community is well trained in how to interview kids. That's really the entire foundation of a good prosecution, whether it be civil or criminal or otherwise. The kid and the detectives and social workers. And the one last thing that the detectives need to know how to do and child protection is to corroborate. You know, as part of the Child Welfare Project at the Center for Child Advocacy, myself, Prosecutor Freed, Susan Curcio, who's on faculty, and a couple of other folks, and some DAGs, we created a curricula to do some trainings for child protection for DIFAS here in New Jersey. And, you know, we try to teach optimum skills for being good witnesses in court. This program is about being a good witness in court. And in order to be a good witness in court, you need to understand not only the civil side of child maltreatment, but also the criminal side of child maltreatment. You need to not only be a good child protection worker, child protection specialist, intake worker / investigator, because that's what you are, those who do that, you intake workers. You need to be a good civil side, but you also need to have an appreciation and a respect for the law enforcement perspective. Because at the end of the day, the credibility of the information that you develop is always in play. Always. Whether it happened is important, whether you're in civil court or not. And whether it happened is more likely to be demonstrated if you have a little corroboration. So everybody ought to be thinking about looking for corroboration. You know, if a child said that he used a ratty old belt and it was brown, and he keeps it in the closet, go look in the closet, man. See if it's there. Ask mom if he ever owned such a belt. If they said they watched a particular program the day they got molested, you don't even need to pick up a TV guide anymore. I used to say pick up a TV guide. You know, on that iPad there, I can search back 20 years worth of television shows. Find out if that show was on television then. We talked last week about tying the molest to anchors in time, to landmarks in that child's life, and also things that happened during their day, during the time of the molest. And we talked about connecting up a TV show to their experience so we understand when it happened, so we know what day or date that the molest occurred. Don't let the whole case ride only on the child. Just because the child said it doesn't end the investigation, right? You need to look at what that child said and say, what can I do to help support what she said? And I'm telling you, if you look at what that child said, whether it comes from your notes or the review of a police statement or the review of a police video or some other source, whatever it is the child said, if you look closely at it, you will find, at a minimum, 2 or 3 things you can corroborate independently. They may be little things. They may be things that don't prove it happened, but they help support that child's recollection. They help support that child's believability. They help demonstrate that that child, in some small way, is pretty good at remembering past events. They're pretty good at remembering the historical facts of the time when this thing happened, when this molest happened, or whatever it is that the case is about. For example, if they say it was when they had the NCAA championship game, that's when it happened. Take a look and see if the NCAA championship game was in early April in 2011. If it was, does that mean he molested her? No. She could have learned that from picking up the newspaper or hearing somebody talk about it at school. But the more little things, the more the kid becomes a little bit more believable. And people are so primed to want to disbelieve the word of the child. We can't let the whole case, whether it be in civil court or the family court or the criminal courts, rest on the shoulders of the child. Now, Chapter 4 is about investigative interviewing. I just expressed to you how the attack occurs on the interviewer. We're going to get into a little forensic interviewing, and some of it may be repetitive to those of you who took the course already. Some of it may not be repetitive. Some of it you may be hearing for the first time because you have not yet taken forensic interviewing. But it's worth it to hear it again if you've heard it before. Children's memory capacity. You know, little kids are pretty good at remembering stuff. The perception is that kids under 5 aren't good at remembering stuff. But that's not true. And there's plenty of research on that. What's the problem with kids under 5? Is it remembering or something else? Alp?
Articulating?
Yeah. Expressing what they remember is the challenge, right? The maxim or the handy phrase that I like to emphasize is, children know more than they can tell. And when a professor has handy phrases that they like, and they say they like it, and they give it to you, and they think that it captures an entire area of what they're teaching, it probably would be on the exam. So children know more than they can tell. Now, I might not use that exact verbiage or those exact words, but I'm probably going to hit on that concept. Children know more than they can tell. And as Alf says, articulating what happened is the challenge. That's why anatomical dolls can be effective props to help kids express themselves. That's another way kids can communicate, and we'll touch upon that in a moment. Okay? In any event, kids know more than they can tell. Even children as young as 2 or 3 years old can accurately recall information about personally experienced events over long periods of time. Memory is not perfect in children, nor is it perfect in adults. We don't want to, Professor Myers points out in quoting Lindsay and Reed's research, we don't want to exaggerate, though, how frail memory is. It can be robust memory. People's memory can be pretty good. Nevertheless, we need to scrutinize people's memory, and we need to be concerned about suggestibility. Suggestibility, and this is just one definition, there's one in your text as well, and you're going to be questioned about suggestibility on the final. But, and I'm paraphrasing now, suggestibility is the manner in which an interviewer, we'll look at it from the context of an interviewer, the manner in which an interviewer or someone who questions children can influence and distort their memory. It's the manner in which an investigator or interviewer who's questioning a child can influence or distort their memory. And or distort their memory? Through their language and through their behavior. So a person who's questioning a child can influence their memory and or distort it by the things they say and by the things they do. And you want to get even more deep, the way they say it. The way they say it can be suggestive as well. Because it's not only what we say, it's how we say it. And the inflection of the words that we use, the tone that we use, the manner in which we look at children, the combination of all the things. That's why video recording children's interviews is such an effective way to make a record so that people can examine whether an interview was suggestive or not. An audio tape isn't good enough because suggestibility arises from a lot more than just what we say. It arises from how we say it and the manner in which we say it. What we're wearing can impact the suggestibility of an interview. Many years ago, there was a game show, and it was a really good game show, and perhaps it's back on one of the cable channels. I don't know. Maybe you do. I don't watch too much television anymore. But there was a show called Password. And it wasn't like the $25,000 Pyramid or any of these shows that are cop-outs where they say, it comes in a bottle. It's not Pepsi-Cola, but it's, you see it all over America. They have stores in China and everywhere else. It's the real thing. It's not Pepsi-Cola. You don't say all those words. You say things like bottle, drink, beverage, liquid, soda, Pepsi, and you hope they get Coke, right? But if you ever watch Password, who's some of my older people? Any of you? You remember Password?
Yes.
You remember?
And heavy duty.
Well, heavy duty's a little...
Thank you.
I don't know heavy duty. What's that? Yeah, I heard about heavy duty. There were inflections that everybody knew who played password. If you wanted something to be the opposite, you inflected one way. Hot, cold, $2,500, right? Now, if you said hot, that meant something else. I don't know, the opposite of a cock or a similar sound. So the way you expressed the clue, the tone, the inflection, and your body language communicated volumes. That's why if you had a transcript of password, it would be fundamentally different from watching the program. In the courts, they had for years, and still do, a person known as a stenographer who uses a form of shorthand that is highly computerized now, where they type down everything that's said in court. And in most of the trials of my career, in fact, to this day, the court reporter, although they're being phased out for economic reasons, there are very few left, but the court reporter would be asked to read back the witness's testimony. When the jury was deliberating, they say, you know what? They pass out a note, the judge would get the note in a criminal or civil trial, and he'd call the lawyers, or she'd call the lawyers up, and the judge would say, listen, they want to hear the cross-examination of John Carmelo. And we argue about what that means, we argue, the defense lawyer would say if it was a good witness for the state, they should hear all of the testimony, even though they only want the cross-examination. But at the end of the day, what would happen is that court reporter would come out and read from his or her notes. And it was almost like on an adding machine paper. It was skinny and long, and it created a pile because it would fold into itself. Anyway, they'd be going through this thing with their thumbs, and they'd be reading. You know, they'd read in a very flat, monotone way because they don't want to favor one side or the other. So they almost had to become computer-like in the way they expressed what the person said on the witness stand. But it didn't capture what really happened in the courtroom, right? Because behavior, inflection, tone is critical to meaning and to communication. So suggestibility can arise from not only the words, but also the language, behavior, the tone, and all of those things. So in understanding suggestibility, we need to understand that kids and people rely on two kinds of memory. One kind of memory is called free recall. Free recall. And simply stated, free recall is that amount of memory that any one of us, any person, can call up, express. It is that amount of memory that a human can express, a person can express, without any prompts or cues. To make that more understandable, free recall questions are like this. Tell me about that. I'll make it a little bit more specific because unless I introduce a subject, no one knows what I'm talking about. It's still a free recall question. Tell me about your ride to school today. I didn't even say drive. I can be even more free recall or more open-ended in order to get a free recall recollection. Tell me about your trip to school today. That trip is as neutral as possible. Maybe you took the train. There's a train station right over here. It goes right into the campus. Maybe you drove. Maybe someone drove you. Maybe you live in one of the homes right near the university that take in boarders and you walked here. I don't know how you got here, but I didn't ask anything suggestive. I asked you, tell me about your trip to school today. And I didn't focus you or direct you anywhere. That calls upon free recall memory. I want to know about the whole trip, essentially. I don't say that. That's the unstated question. You might say to me, well, what do you want to know? You know, especially if you came from South Jersey. Right? What do you want to know? Just tell me about your trip. Well, I got in the car, you know, and I stopped at the Wawa, I got a tall coffee, I got on the Parkway at 117, I drove up, the toll was packed. A bunch of different things may have happened. But when you got to the toll at the Union Toll Plaza, if there was a car that crashed into the median, and there were police personnel surrounding it, and there was a man laying on a gurney, and you told me about that, that information would be the highest quality information because it arose out of free recall. I didn't ask you about that. I asked you to tell me about your trip. I didn't give you any cues or prompts. Now we're going to contrast that with cued memory. Cue, like acoustic, C-U-E. Okay? Cued recall. Cued recall is that memory that a witness is able to express with the use of a cue or a prompt. And a cue can be words. But nearly anything can cue or jog a person's recollection. In the hypothetical I just gave you, I would say to you, tell me everything about the accident by the Union Toll Plaza. What did you see? Or what happened? Now that's not a free recall question. That's a directed recall question or a cued recall question. I cued you about what I wanted to know about. So tell me about your drive to school. Tell me about your trip to school today. And tell me about the accident at exit, what's Union? I don't know, 148? 140? Tell me about the accident at exit 140 near the Union Toll Plaza. That would ask for cued recall. So we want to start with, when you're doing interviews, with as open-ended a question as possible. Tell me about your trip to school today. And then we want to kind of funnel downwards if we don't get the information that's necessary, funnel downward to more directed questions, more cued questions. And here's the maxim, if you will. Here's the saying. Here's the turn of the phrase when it comes to free recall. Free recall questions get the highest quality information, but not very much. You get the best information, but not a lot of it. And by best, I use that term advisedly. What I mean is, it is the closest to the historical truth. So when you ask free recall questions, the research has told us that that recollection is highly accurate. It's not perfect, but it's highly accurate. On the other hand, when you ask directed recall or cued recall, C-U-E, when you ask cued recall questions, you get more information. Remember, with free recall, you get great information, but not a lot of it. With cued recall, you get a lot of information, but it's a little less quality, a little less accurate. Don't confuse that with it's bad recollection. It's okay to ask cued questions. In fact, it's nearly impossible to interview a witness without asking cued questions. Now, if I change the hypothetical, because if I said to you, tell me everything about your trip to school today, eventually you would get to tell me about the accident. Because it's an impactful event, right? Cars crashed, there's police, there's emergency personnel, there's a guy on a gurney. It's pretty difficult to imagine that somebody telling that story won't tell that part. But let's say the issue was all about the toll taker, and there was an investigation into whether he was embezzling. And we wanted to know about the toll taker at the Union Plaza at 11 o'clock at night. And for purposes hypotheticals, the only toll taker. And you went through it. If I said to you, tell me everything about your trip to school tonight. And you would tell me this, that, and the other thing, but you never told me about what happened in the toll. In fact, I don't even know whether you went through the easy pass or through the toll. Now, I can even ask, well, tell me more about that. Tell me more about your trip here. I don't know. I got in a car. I drove there. You know, there was no accidents. The weather was clear. I stopped at the Wawa. I had a big coffee. I was listening to the radio. I got bored. I put on a sports channel. Tell me more about your trip here. Tell me more. Tell me more. Did you go through the easy pass or did you pay with cash? That would be a suggestive question. Give me a focused question that would get to the inquiry. Al, go ahead.
What was the method of payment you used for the toll?
I'll take you back a little further. Did you pay some tolls during the trip? Tell me about them. What tolls did you go through? Well, I went through the middle, 131, and then there's one by Union, there's one by Essex, there's a Union in Essex. Tell me about the one by Union, you know? Now I'm focused. I'm not giving information. I'm just asking. Tell me about that. That's cued recall, right? I'm taking you to a certain part of your trip and focusing you on what I want you to remember. And now I'll get more information. You'll tell me more, obviously, than you did with just telling me about your trip. But when you compare the quality of recollection, the quality of accuracy with free recall, you always do better with free recall than cued recall. That's not to say that cued recall is bad memory. It's still good memory, it's just not as good. Doesn't mean if you ask a cued recall question that they lie or make mistakes or get it wrong. No, they still can get it right. It's just that it's not as accurate. So the preference is always for the highest accuracy, right? So we want to ask questions that are open-ended and call for free recall. So you have free recall and you have cued recall. There's a form of free recall. There's a form of cued recall. And we kind of think of these as kinds of memory. Free recall memory and cued recall memory. Now these are informal characterizations of memory. People who study human memory have an entire vocabulary to describe the minutiae of how the human mind works. But for our purposes, we will call it free recall memory and cued recall memory. And underneath cued recall memory is a form of memory that is prompted typically by things or places. Things other than words. Can someone tell me what that kind of memory is from chapter 4 in Professor Meyer's text? What's the name of that cued? What kind? Focused? No, that's not what I'm driving at, but that's in the ballpark. It's a kind of memory that's in one of the subheadings. It's a form of cued memory. Yes, very good. Recognition memory. Recognition memory. Now that you said it, you've got to tell me what it is. Think about the word, though. If you think about this word, when you're taking the exam, you need to think about recognition. Look at the word. The word tells the answer. What is recognition memory? Well, it needs cues, but I told you it's a form of cued memory.
Maybe that's John Vestibular.
Okay, don't read the book. What's the root of the word recognition? The word recognition. What's recognize? So what might you recognize that might jog your memory? Anything. Make up an example. Picture place. Yes. I don't mean to put you on a hot seat, but you gave me the answer, and I want you to appreciate what this recognition memory is. It could be a picture, it could be a place, it could be a thing, but there are lots of different stimuli. I use that word from the book. There's lots of different stimuli that jog the memory. In court, they call this refreshing a witness's recollection, and it's a rule of evidence. They allow you to refresh a witness's recollection. But we're not talking about a witness on the witness stand. We're talking about an investigative interview. And that's a particular kind of memory that arises from a certain kind of cue or prompt. Because remember, the stimuli acts as a cue or a prompt. When I was asking Alp about the trip in the car to school, to class tonight, I said, tell me about what happened by the Union Toll Plaza, or tell me about the accident, or tell me about how you paid, or when they went through tolls. That is, the stimulus there is a word or a group of words. So I'm asking a question that has information, and that's used to jog the memory. Recognition memory, focuses on usually stimuli other than words. You recognize something. You recognize something and it jogs your memory. It could be a smell. It could be a picture. It could be a place. Okay. It could be the way someone hugs you. It could be a cold breeze on an autumn night. It could be nearly anything that acts as a stimuli. But almost always, that stimuli takes you back to what? To the events. Very good. To the events. Almost, doesn't have to always do that, but usually it's something related to those events. You know? What's an excellent example of how police officers use recognition memory with victims of crimes sometimes? Who said that? Good job. Showing a lineup. A police lineup is the most compelling example of recognition memory, right? They're asking you, is there someone in the lineup who is the person who snatched your purse? Now, we don't do lineups anymore where people stand and they make you turn sideways and say stuff. That's for television and film. They used to do that. It's a lot of work. You gotta get together 10 guys. They all have to look Italian. They all have to be about 6 foot. They all have to speak in a certain way. That's difficult to put together, you know? What we used to do was get 8 photographs. And even that was a challenge back in the day. 10 years ago. It's a challenge. Now, many big police departments had picture books where they had photos of, they call mugshots, right? Photos of people who were arrested in the past. I remember when I first took a job as a security officer, I was working in a pizzeria in college and high school, and then I got a side job working at Sears in security, and this was the height of the security game for a teenage college student, and I got the job there. I had worked in a music store at Willowbrook Mall, but this was far more paramilitary. They had all these rules. I was hiding by the women's cosmetics. I was hiding in the ceiling, looking through those things there, what do they call those things, vents, peering down through the vents, making sure none of the women, typically women, I guess a man could shop there as well, but we were looking at mostly women, in fact, not all women, who were throwing stuff in their purse. And in the men, you want to watch the wrenches and the little what do they call those things? There's a ratchet, and then there's a lug nut, the big, so you'd be in the ceiling there. Perhaps they still do this in Sears and these big stores, I don't know. Now they have cameras, you can fit them in a pinhole. But in any event, when I first started working there, they said, come and look at the books. Whenever you bring someone and take them into custody, we call the Livingston Police, and we do this, that, and the other thing, and we take their photos, and we have these photo books. So, you know, I just started, I'm thumbing through the book, and I go, it's Mr. So-and-so, the theater arts teacher. Hey, it's my friend Zoms, man. What's up, Zoms? Hey, it's Neil Maloney, too. What's up? I saw more kids I knew, and a couple of teachers. I was like, oh man, this shoplifting game is pretty involved. All these characters, shoplifters. But much law enforcement keeps these picture books, these photos of persons' arrests, and we used to go in those books and look for a dozen photos that resembled what the witness, the victim, said the suspect who attacked her or him looked like. And you have to be as close in appearance as possible. Otherwise, the lineup is not effective and can be dismissed by the court. They call this an out-of-court identification. The entire identification procedure can be thrown out of court if the lineup is suggestive. Remember, we're talking about suggestibility? We've got on this issue because of recognition memory. The person sees the person who attacked her, and that jogs her memory. But the other issue that arises in these lineups is suggestibility. And the key is not to be suggestible in the way you make up the lineup. The classic example that you see, like in the New Yorker or something, is there's a duck, there's a nun, there's a guy with a little, a human with a little scruff on his face. There's a statue of George Washington, and there's an empty chair. And they go, there's the guy, the only human in the lineup. That lineup would have the functional equivalent of one, obviously. There's all of the foils are non-human, and thus it's highly suggestible. But when you really get into defending these cases, you'd be surprised the kinds of issues that arise. You know, one time I went before a judge, and this was early in my career, and there was a strong-arm robbery of a travel agency in Patterson. And the man said that the persons who attacked him, this was pistol whip, gunpoint, they took cash and other stuff. The persons that attacked him were Peruvian Hispanics. And that's what he said. He was specific as to, and he didn't really get into it. He just goes, yeah, a couple of guys, they were Hispanic. I think they were Peruvians. They came in and he said everything else. And the police in Patterson back then, and I had nothing to do with the investigation. I got the case much later. They made a lineup, and the guy gets arrested, and the victim points to his picture. And a defense lawyer was a woman defense lawyer who I thought made a very effective argument. You know, I didn't see it. I didn't pay much attention to it. In my mind's eye, it seemed to be a good lineup because they were 8 Hispanic men. And they all had, you know, a little mustache. And the person who did it supposedly had a little bit of a mustache. They all had short brown hair. I mean, there were lots of factors. There were lots of factors upon which the pictures were very, very, very similar. And to the police officers who put it together, it was a very good lineup. But the defense lawyer, who was Latina, made a very powerful argument, except that she didn't have a very receptive judge. But as I sat there, I go, that's a pretty good argument. The 7 foils, there was the one guy who was the defendant who was sitting in the chair, and he was on trial. They called the persons other than the target the foils. The 7 foils were all Caribbean Hispanics. He was a South American Hispanic, and he had a certain jawline, a certain look, a certain look of people who have the South American Indians in their heritage. Peruvians do not look like people from Madrid, you know. And South American Hispanics have a different facial structure than Puerto Rican Hispanics. And if you looked closely at the photographs, he stuck out. If you looked at him and said, who looks like the Peruvian, he was the only guy who looked like a Peruvian. That's not to say there aren't Peruvians who look like Hispanics, and there's lots of variability. But certainly, if you look at Hispanics, there are certain facial structural differences. And after I looked at it through the filter of that woman's argument, the other lawyers, I was like, wow, it kind of jumped out at you. That was a suggestive lineup. Very suggestive. Experts who study this would say that that lineup had the functional equivalent of one person in it, because all of the foils were meaningless. To the traumatized witness, the only person who connected with him was the defendant, because he was the only person who had that facial structure. And she argued it meant something to him because he not only said it was Hispanic, he narrowed it down to Peruvian Hispanic, which meant something to him. That means he discerns a difference in the facial structure, or the look, if you will, of a Peruvian Hispanic versus a Caribbean Hispanic or a European Hispanic. So, number one, that's an example of suggestiveness, right? And the other thing is, when the witness saw that, it jogged his memory to the robbery. He was ultimately acquitted by the jury, by the way. I didn't try the case. I handled the pretrial hearings, and then I moved over to child abuse and sex crimes, but he was eventually exonerated by the jury. And he may not have been the guy. Another example of what police do to tap into recognition memory. A lineup, a photo array. That's what we call a photo array when you show pictures. By the way, it's a lot easier to do photo arrays now because you don't have to get the pictures from those books. Everybody in this classroom, everybody in New Jersey has a license photo now, and we have access to them in my office. Everybody in law enforcement has access to everybody's DMV photo. All, whatever it is, 12 million people that live here. So we can get pictures like that. It's very easy to make. With computers and digital photo arrays, very easy to do what you need to do. But what's another example of what law enforcement might do that taps into recognition memory? Remember I said it's any stimuli. You want to get more information from the witness, from the victim. What other things could you do with that witness to help jog their memory? Excellent. Take them to the scene of the crime. Classic example of tapping into recognition memory. Not far from here, I may have told this story to the folks in the forensic interviewing class, but not far from here were the Clove Road apartments. Across the street from the Clove Road apartments, which are still there, by the way, I think they're more formal dorms now, in the shadow of this university, there's the Montclair State radio station. And there was this group of men, young men, a student among them from Montclair State, who picked up this 15-year-old girl, take her back to the apartments, and eventually sexually assault her near the radio station tower. I'll spare you the gruesome details, but when I was beginning to try the case, preparing to try the case, there were some of the witnesses I had to make deals with, some of the rapists, because the girl had ran away again. She was 15 and she was a runaway, and I didn't have a victim. I think it's the only case that I know of in New Jersey where I tried a rape case with no victim. All I had was her little jeans. And they were, I remember them, they were mud brand jeans. They were full of blood and dirt and mud. But the brand was mud, and they were like size -1. They were real little. And I showed them to the jury, and I had her father come from Texas. There was no more poignant moment during that trial than when I brought up the bloodied jeans, and I showed them to Dad, who was estranged from the mother, and she lived in this area, and she was not as cooperative as the dad was. He came up, I think, from Texas, but in any event, he came in, and he said, those are my daughter's jeans, I know them, and he also identified her picture. So I had her picture, and I had her jeans, but I didn't have her. But I knew what happened to her, and I knew what they did was vile and criminal, so we prosecuted them. But because it was a group assault, I needed to cut a deal with two of the rapists. One didn't do anything. He didn't do anything good, but he didn't do anything bad either. He ran away, he saw things, and the other one was actively involved, and I had to cut a deal with him. And there were two other young women, but these are 19-year-old kids who were guzzling liquor and acting foolishly and immature. And there were two young women there who weren't at the scene, but also were witnesses. I brought the two young women back to the place, because they came to get the girl's body and get her in a car, get her over to the hospital. So they were there. And then the one guy who I made a deal with, he came, and they came at different times, and I said, walk with me. Where did she hit her head? Where did she begin bleeding? Where did she vomit? Where did they take off her clothes? What did you see? How did you get her from here to there? And if I asked her that in my office, I would have gotten a lot less information than asking her, just two young women, and the young man who was involved in the molest, asking them at the scene gave me a lot more information. It also made me better in the sense that I understood the scene a lot better. I knew the place and the context of how this all went down. Very powerful. Every advocate ought to go to the scene if you do what we do. That is, prosecute cases, even DAGs. You ought to go to the house if you get in there. Take a look around. I always go. I learned it from an old judge. And it's common knowledge that good prosecutors will go to the scene. But more importantly, it jogs the memory. It helps you tap into that recognition memory. And I got a lot more information, quality information, from these witnesses by taking them there. So that's another form of cued recall, right? You got free recall, you got cued recall, and you got the subsection under cued recall of recognition memory. Recognition memory. And it's good. Recognition memory is good. It's a way to ask good questions. It doesn't have to be suggestive. Okay? It doesn't have to be suggestive when you ask questions or bring witnesses to places or expose them to stimuli. It isn't necessarily suggestive. What's an example of a prop that we use in child maltreatment investigations that takes full advantage of recognition memory? Go ahead.
The dolls?
Yeah, the anatomical dolls. Thank you. The anatomical dolls. Very valuable. Very effective. You saw, those of you who took forensic interviewing, you saw the dolls when I showed you how they worked last semester? Fascinating. But the dolls, they cue the child's memory through recognition factors. number one, when they're manipulating the dolls, and this is the daddy, and this is the Gabriella doll, and he did that, and he did this, that takes them back to time and place. That's like taking the young ladies and the guy over to the dirt road near the radio station. While they are expressing what happened and acting it out with the dolls, they're there in mind. And that act helps them remember better. Okay? That's an example of a prop helping with recognition memory, and that's why it's important for us to understand that in the area of child maltreatment. There's something else called script memory, and script memory is that kind of memory that happens when people do repetitive acts. They don't really remember any distinct act or any discrete act. They remember how it usually happens. What's something repetitive that we all do? There could be a variety of things. Give me an example of a repetitive act. Brush your teeth. Anything else?
Wearing your clothes.
What?
Wearing your clothes. Clothes.
Put your clothing on in the morning. Brush your teeth. Take a shower. Right? Things that you do over and over again. Now these are mundane things that happen every day. And if you had to explain to me how you brushed your teeth 2 weeks ago, or on the Monday before Easter, it'd be nearly impossible to do. But what you could tell me is how you usually do it, how it typically happens. Now, if you got a new toothbrush, you got one of these toothbrushes that use pulsating light or something, or high-tech digital toothbrush, you may remember the first time you used that. But eventually, if you use that over and over again, that becomes routine, right? So, how does that have anything to do with how kids get molested? Tell me. That's not what I'm getting at. What kind of repetitive... What happens to kids in our world over and over again sometimes, tragically? They get molested over and over again, right? And very often it doesn't vary. In fact, in the forensic interviewing class, I was just grading the online course. They did the Jane Doe. Some of you who took the class with me last semester remember Jane Doe wrote 35 pages of how she was molested by her father. And there was a period where it happened the same way, night after night, week after week, month after month. And if you ask a child, well, tell me what he did, the first time or the middle time, or when you lived on Market Street. Well, if the actions were repetitive and not varying, they didn't change, the kid can never tell you about, in most cases, any single incident. All of them kind of melt into one another. It becomes a script memory. Okay, it's almost scripted, like a Hollywood script. Like Groundhog Day, that film with Bill Murray from a few years back. It's the same thing over and over again. So what you need to do is ask them how it usually happened. And that's okay. That can be competent evidence. Or was there a time that it was different? Thank you. Was there a time that it was different? Was there a time that it happened in a different location or place? Did it always happen in the bedroom? Was there a time? Now maybe he did the same act. Maybe he put his hand down, tickled their butt, did X, Y, and Z. But it happened some other place. So we can investigate or talk about that. Anyway, back to memory. That's scripted memory. Scripted memory. There's something called recovered or repressed memories. We're not going to get too much into that. There is some mention of it in your textbook. There is a fair amount of controversy in the field about recovered or repressed memories. They are connected because the thought is that some witnesses, some victims, are so traumatized by their victimization that they compress those memories. They repress them, not compress them. They repress those memories. They squash them, they squelch them, they lock them up, and they don't remember them. They put them away. Now, we know that people deal with trauma that way. I'm sure you might remember things that are unpleasant or really bad things that happened in your life or traumas you may have experienced. I mean, the death of someone, the death of a sibling or a parent. I remember my mom dying. I don't think about it. I do everything in my power to not remember that stuff. So, it doesn't really bring much value to me. And if ever I'm watching a show where there's an oncologist or they're at some fancy cancer hospital, sometimes that'll come back. I just shut it down. Put that memory aside. Squash it. That's a little bit different because I have a recollection. See what I'm saying? I have a recollection. So even though it's repressed, it's not completely repressed. The assumption with this class of victims is in the repressed, recovered memory controversies, or they don't even know it happened. That would be like, I didn't even know my mom died here, where she died. I don't even know that story. What? She died? When? I was there. And then through therapy, and through guided imagery, and through talking and thinking, I remember now. She did die, and it was here. As you might expect, a fair amount of controversy about whether this happens in the complete way that it's shut down, and controversy arises from the manner in which it's extracted. Guided imagery, what's that? You asked her over and over again, you gave her a scenario, you told her it happened and said maybe it happened, and so there's a lot of controversy there. Suffice it to say that it's controversial. And it is perhaps a form of memory, or a way that people deal with memories, not deliberately, but the way that, the human mind deals with trauma. Trauma. There is some research on stress and memory, and the research is inconsistent. There is research that says that stress might degrade memory, but there's some good research that says that stress probably enhances memory. That a stressful event might make things more memorable. Okay? In fact, that is what the more recent research states. Studies of children's memory for stressful events supports the view that the core features of such events can be well remembered. Stewart and Stewart did a research project in 1996, at least they published the results, where kids went through a painful medical procedure, and as a group, the children who were more upset reported a greater amount and more accurate information at an interview 6 months later. So the kids who were more upset about this painful medical event remembered stuff better 6 months later. However, there were a few of the most highly upset children who were really wrong. So, look, this is one study. We don't know what it tells us in the long run. But it kind of feels right in a way. The kids who were not that stressed had less accurate recall than the kids that were really anxious and really stressed and really affected by this. And then you have the kids that were, and I'm adding this word, I don't know that it's, they were hysterical. They were totally out of control. They were way wrong. And that kind of makes sense. Somebody who's so stressed, so jacked up about what they're experiencing, you might feel that their powers of perception are not going to be good. But that's different from high stress. High stress and then off-the-chart stress are two different things. Hysteria is different from high anxiety. Any questions so far about what we've been talking about? Excellent. Well, we talked about suggestibility. I told you that it refers to how memory can be distorted or changed by the use of questions or behavior. It's important to realize that there's no simple relationship between a kid's age and their vulnerability to suggestion. I'm going to give you the broad strokes, and this is what I hope that you recall. Preschoolers are the most suggestible. They are not completely vulnerable to suggestion. They can remember things and recall them in a highly accurate way. But they are the most likely to be misled. Preschoolers, 5 and less. From 6 to 10, 6 to 10, maybe 11 years old, more suggestible than adults, but less suggestible than preschoolers. As you might expect. The little ones are the most suggestible, the middle kids are somewhat suggestible, and then kids 11 and above are mildly suggestible. That is, kids 11 and above are no more suggestible than adults. That's what the research tells us. Now, adults are suggestible. We talked about photo arrays and photo lineups. We're talking about adults who've been attacked and mugged. And the courts are very concerned about suggestibility in photo arrays and in lineups. So suggestibility is a problem for any human. Because the memory is not concrete. The memory is not as detailed as you might think. The memory doesn't act like some computer hard drive or some video recording machine. It just doesn't work that way. There are fuzzy aspects to it at the margins. And sometimes even the central details can be confused or confabulated or interchanged. So we're all vulnerable to being misled. And time makes it more likely that we will fall prey to suggestive questions or behavior. Whoever you are. The more time that goes by, the more the recollection degrades, and the more potential there is for influence, or for someone to fill in the blanks with questions. In studying children, children are more suggestible about the peripheral details than the central events of what happened to them. Children are more suggestible about the peripheral details than they are about the core aspects, C-O-R-E, the core aspects of what they experienced. Someone tell me an example of a peripheral detail in a case where a man comes in night after night and kisses his daughter's vagina and rubs his penis on her butt. Tell me about the kinds of questions you would consider to be calling for peripheral details. What's a peripheral detail in that scenario that you might ask or some investigative personnel might ask? Al, go ahead.
What was hanging behind the door?
If that was relevant, yes, that is a clear peripheral detail.
What she or he was wearing.
Yeah, as much as that might be important or helpful to credibility and understanding of what happened, what they were wearing I would consider a peripheral detail, and we ask that all the time. Well, what was he wearing? Well, what were you wearing? You know, and especially if it's a chronic abuse case, it calls for what kind of memory? Scripted memory. Scripted memory. The best you're going to get is, well, I usually wear, and a good interview says, tell me what you usually wear. Well, tell me what you were wearing. I don't remember. Well, what would you usually wear? What do you wear when you go to bed? Well, I usually wear a nightshirt, or I usually wear sweats and a t-shirt, or I usually wear jammies, or I usually wear whatever. We'll take that. And that has meaning. That has credibility. That has persuasiveness. But that is a peripheral detail. So you've got to watch your question. That is an example of a peripheral detail. You know. So you were wearing your pajamas when you went to bed that night? Yeah. Now, maybe that kid was wearing a smock or a nightshirt or sweats and a tee. Number one, she may have been misled or bit on the suggestive question or adopted what you said. And it's not exactly true or true at all. Or she may interpret the word pajamas as meaning what? It's all about words eventually, you know. Does pajamas have the specific meaning to some kids? Well, could be. It could be pants and a top. But if she was wearing sweats and a tee or pants and a top that weren't coordinated, might they conclude that that's just another form of pajamas? No?
I would think so, because it's whatever they go to sleep.
Well, that's what I'm driving at, and that may be wrong, but people sometimes think of these words almost as generic. Now, you might say, nah, to most people that means a coordinated top and bottoms or something manufactured for sleepwear.
It's a different material.
Well, I know that and you know that, but the question is, do kids interpret it that way? You know, is that what they're concluding? Or are some kids just classifying all nightwear, things they wear at night, to be PJs or nightwear? I don't know. I don't know the answer to that. But the bottom line is that's a peripheral detail, and they're more suggestible about it. What's another example of a peripheral detail that we might ask kids about what happened in a molest scenario?
Is the lights on or off?
Was the light on or off?
There's a blanket. Did you move the blanket? Did the child move the blanket?
Was there a blanket on the bed? Was there a blanket on your body? Who moved the blanket? Was the blanket moved? Where was mom? You know, I hear that question all the time. Now, that's an interesting question, and it could be an important question. But that's a peripheral detail to the central aspect of the molest. That doesn't mean that they don't have a sense of where mom is. All I'm saying to you is that is not a central detail. Thus, if we ask the question in a leading or suggestive way, they may embrace that question as the answer, rather than it arises out of their memory. They don't remember it, but they accept it. Give me an example of a suggestive question about a peripheral detail, about mom. Well, she's in the bedroom. Dad's molesting her in her own bedroom. Ask a leading question. Ask a question that says what mom was doing.
Was your mom sleeping?
Was your mom sleeping in her bed? Yeah. Maybe. You know, if we could tell kids directly, do you have an independent recollection of that? You know for sure that she was sleeping in the bed? And they were able to communicate to us on an adult level? They go, no. I think she was. That's where she usually is. That's where I last saw her. Maybe. The bottom line is that is a peripheral detail, and if you give them an answer, sometimes they'll embrace it, and they will be misled. But if Daddy put his hand on her vagina and put his penis against her butt, and you said something to the effect of, again, I'm not advocating suggestive questions, but we're looking at kids' vulnerability to suggestion. And when he put his mouth on your chachi, how did that feel? He didn't put his mouth on me. That's a core detail. That's a suggestive question. It provides some set of facts. But the child is less likely to embrace that. And they're less likely to embrace that because it is asking for a central aspect of their victimization, and that stuff is better remembered. If it's better remembered, they're less vulnerable to suggestion. If it's more weakly retained, you're more prone to suggestion. Those are peripheral details versus central details. Any questions about that? I said earlier that there are kids who are real little or suggestive, kids that are older are a little less suggestive, and kids 11 and older are not more suggestible than adults. But age alone doesn't determine suggestibility. It's the kind of questions, it's how long ago it happened, it's how suggestive the questions are, it's the demeanor of the interviewer. So there's no simple relationship between suggestibility and age. Age is a factor. Age is a factor. Okay? But there's lots of elements that go into whether people and children can be misled. As Professor Myers tells us, suggestibility is multiply determined. It depends upon situational, developmental, personality factors, the kind of event, how well it's remembered, the type of information, central versus peripheral, the way the interviewer conducts the interview, the behavior of the interviewer, the way they're dressed, their tone, their demeanor, their affect, their inflection, there are lots of things that are involved in suggestibility. The more suggestive elements, the more problematic the interview. The more problematic the interview, the more skeptical we ought to be about what was said. So if there are a few suggestive questions, but there's nothing else suggestive about the manner of the interview and it's about central details, you could say, well, a few suggestive questions aren't going to hurt. It's not ideal. Sometimes you have to be pretty direct with kids. As long as you follow up with an open-ended question, you're usually okay, and you don't get too suggestible over and over again. There is research that tells us that people who experience an event are less suggestible than bystanders who watch an event. That has some intuitive feel to it, right? It feels like it makes sense. If you were involved in the 6-car pileup, you're more likely to remember it better than somebody who was a passerby who watched it. Some child advocates argue that the interviewer should not know anything about the case when they do a forensic interview. Don't talk to DIFUS, or DIFUS, don't talk to the school teacher. Don't review the child's records. Whoever is going to interview the child shouldn't know anything about the case. What do you think the reason is that people might advocate that manner of interviewing the case? You may interview. What's that?
Not to influence. Plus, they may come up with a different,
More loudly, I'm sorry. Go
they
ahead.
may come up with a different diagnosis or a conclusion if they don't have any access to the record. Like,
Well, I think the answer is that if you don't have, go ahead.
You want to confuse the child if you're interviewing with.
Well, if you know the facts of the case, you're saying you may confuse the child if you
If
put
he's
your own
been
spin on it.
several times.
Yeah, Al.
It's to reduce bias and suggestibility.
Yeah, but what does that mean?
Well, if you already have an idea of something happening in a certain way, then you're going to try to question the child to get to the answer that you think the way it happened.
Yes. Go ahead.
Like, if you know X, Y, and Z happened, and when the kid doesn't say any of that happened, it's not going to work. Like, you're going to write the report stating that the kid is not fully disclosing what really happened, just like outside the life.
Yeah. You're all on the right track, and you're right. What you're saying is true. That issue is the more you know about the case, the more potential there is for you to ask suggestive questions and for you to have a point of view about what happened. If you don't know what happened, if you have no sense at all of what happened, you're less likely, it's argued, you're less likely to ask suggestive questions or to push that interview, either directly or indirectly, either intentionally or unintentionally, in a certain direction. Because you have some assumptions about what happened. Now, I don't advocate that, and the protocol that I embrace and that I recommend doesn't advocate that. We advocate the opposite, an informed interview. And the remedy for bad interview practice, the antidote for inept interviews, is training and good interview practice. One can know everything about the case that has become part of the record up to the moment you interview that child. As long as you don't communicate what you know, directly or indirectly through language or behavior, as long as you don't make assumptions, as long as you ask objective, neutral, open-ended questions, and ask focused questions only when necessary, and then follow them up with open-ended questions, you do a good interview. And there's so much to be gained by knowing what happened so far. You can know about the child's relationship with the alleged perpetrator, how they feel about that perpetrator. That might be important to know before you walk into an interview room. It'd be nice to know what the words were that the child used to say what happened to them. Did they express shame, or were they matter of fact about it? You're going to have to sit down with this child and communicate with them. And the more you know about their demeanor, their affect, how they feel about the abuse, how they feel about the perpetrator, how often it happened, whether he used threats. You think you might want to know if he threatened her or him before you interview the child? You think you might need to know that before you go into the interview room? Otherwise, you go in and say, did something happen to you, Daddy? No, nothing happened. Okay, thank you very much. See you later. If you know that this child has a disincentive to tell, that they are unlikely to tell because they were traumatized or threatened or they feel shameful or embarrassed, unless you address that emotion, you're not going to be able to get the information. So we recommend, when I say we, the interviewers from Finding Words and from Corner House and the program that I recommend, we embrace what we call the informed interview. The other kind of interview that I described, we don't know anything, is called a blind interview. Now, some people advocate for that passionately. And that's, there's nothing wrong with it. I just think it shortchanges some kids. Many kids, actually. I think we set ourselves up to get less information in a class of victims that is resistant to telling us what happened for a variety of emotional, social, and familial reasons. And unless we tap into those emotional, social, and familial issues for this child, in this case, we're going to miss out on lots of kids who've been molested. Why? To prevent the case where we mess up, where we're too suggestive? Anyway, so that's the informed interview versus the blind interview. Something you need to think about when thinking about investigative interviews. And that's what Chapter 4 is all about. Something else you need to think about, and it's called testing the alternative hypotheses. Testing the alternative hypotheses. This is critical to good interview practice. Not every case gives you a true alternative hypothesis opportunity. But it usually happens in ambiguous molestation scenarios, where the facts are such that the accused, or the person who we are suspicious of, or the acts upon which we are suspicious, can be capable of multiple interpretations. Give me an example. What's an example of behaviors that grown-ups engage in with children that can be misinterpreted as molestation when in fact they are privileged and okay? In the back.
Sitting on the lap.
Lap sitting. Next. Showers end. Baths, showers, lap sitting. What else? I can't hear you.
Kissing on the mouth.
Kisses. Kissing and kisses. I'm sorry? Sleeping in the same bed.
Changing diapers.
Diaper changing, touching their bodies to change diapers. Go ahead. Tickling. What else? Go ahead. Changing your clothes in front of the child. You're privileged to do that. All of these depend upon motive and intent, right? Motive and intent. If the motive and intent of the person was for sexual gratification or sexual satisfaction or to exploit the child or take advantage of the child for sexual purposes or for some other nefarious or criminal purpose or non-innocent purpose. What's another example? Close cousin of tickling. Wrestling. Wrestling. These are very difficult areas of investigation, and they are part of our world. There are many CPS workers in this class. They are part of your world. We encounter them in a significant proportion of our investigations, and they require that we analyze the facts and test alternative hypotheses. Give me one more. Somebody said changing diapers. That's a good one. This can happen from diaper-age kids right up through maybe 5, 6, and sometimes beyond. Say it again. Baths we went into. Baths are highly ambiguous. They need an alternative hypothesis inquiry. In the back. Potty training. What else? I'm thinking of a diaper change, and what happens to little kids sometimes when you change their diapers? Sometimes you also need to do what? Wipe.
Change your clothes.
Change their clothes, and what else sometimes happens to the kids? Well, we hope that doesn't happen. That would solve the alternative hypothesis. But there's the potential for interpreting that as fondling or getting it wrong. Rash. What do we put on rashes? Ointments. There are other times that this becomes an issue, not only for infants and diapers. I call them medicine application cases. You ever have a medicine application case where the guy says, "Oh, we just put cream or salve," or you get these coach dads and doctor dads. I had one of my first defendants, my earliest defendants, Gustavo Ruiz. I like saying their names because I can't, and I remember them. And they're guilty. He knew that there was a history of breast cancer in his wife's family. So he would check her for lumps. He was the original Dr. Dad. Unfortunately, she was 14 years old. I think she could do her own self-breast exam or whatever you call it, but Dr. Dad was doing, maybe mom could do it, right? I mean, there's a lot here. Now we're getting into how you question these cases and how you look at alternative hypotheses. But yes, medicine applications. These Dr. Dad cases, Dr. Moms or whatever. You need to number one, you need to test the alternative hypotheses, and you need to be open-minded. Go ahead. Yeah, well, that's how the Kelly Michaels case started, too. That little boy was getting his temperature taken rectally. Now, there wasn't a concern about whether he's been molested or not. It was the pediatrician, the mom was in a room and all that. But yeah, anytime you're engaged in a behavior that involves contact with the body of the child, and you are privileged to engage in that contact, there's the potential for that child to misunderstand, misperceive what's really happening. And there's the potential for that person, the adult, to take advantage of that privilege and actually molest the child. So the question is always one of motivation. Was it an innocent touching, or was it sexually motivated? And sometimes there's no easy answer. But if you go into that interview and you assume that it's sexual just because, he touched the 6-year-old girl's private parts in the bathroom, then you're not doing a good job, you're not being objective, and you're certainly not testing for an alternative hypothesis. And if you test for the alternative hypothesis, and all you have left is that it was sexual, then you did a good job. It's kind of like a differential diagnosis. Does someone know what a differential diagnosis means? I don't know exactly what it means, but it's a medical term, and I think I have an understanding of it. Anybody here who understands a little bit about medicine, what the differential diagnosis is?
The difference between what happened and what could happen.
No, but that's a very good guess.
Is it two different doctors give you two different diagnoses?
That's another good guess, because the words kind of fit, but no. Differential, different diagnoses. What happens is, you know what who the master of the differential diagnosis is? And you see the whole show is based upon differential diagnosis. The entire show. House. What do? They get a set of symptoms, and they rule out everything that might arise from those symptoms. Sometimes they get that set of symptoms, and then they gather additional symptoms, which takes them in one direction. But, you know, you go in there and say, listen, I'm coughing up, I have phlegm in my throat, doctor, I got a headache, I'm sweaty at night, I got a bit of a fever. Okay, well, that could be 17 things. So then you ask another question as a doctor. You know, I don't know what it might be. I mean, are your palms sweaty? No. Okay, that rules out this. Has this been happening for more than a week? No. Okay, that rules out that. Is there a history of X in your family? No, that rules out that. You keep ruling things out until you're left with the diagnosis. And diagnosis is art. It's not science in many cases. Now, if they take a blood test and they find bacteria or they find strep, you know, that's different. That's a diagnosis that's medically and clinically confirmed. But very often you go to the doctor, it's not very satisfying. You walk out and go, oh, don't worry, you got this here, take this. And, you know, I'm not feeling it, doc, that you got it right, but the opposite happened to me a few weeks ago. They're like, remember when I put February 21st, I had to post the lecture? The doctor's like, oh, it's bacterial. No, it's not bacterial, it's viral, there's no medicine for it. Thank you, bye. And I don't go to the doctor a lot. I wait and wait and wait. And I was bad. I was like, you know, I don't like taking antibiotics. But this was one time I go, you know what, let me just get some antibiotics, man. I haven't gotten them in 4 or 5 years. He wouldn't give them to me. I didn't argue for them, but he was like, nah, this is viral. I know it is. Okay, nothing for you. Back to kids in ambiguous circumstances. What are some of the things you need to know about in every one of these cases? You need to know about the surrounding what? General word. Surrounding circumstances. Context. Context is the key. Context is the key to clarifying an ambiguous molest. If dad is putting medicine, I'll give you a medicine one. Dad's putting medicine on his daughter's vagina. Okay, maybe she needs medicine. What's the context? What time of day does it happen? What does he say? Where does it happen? Did the child ask for the medicine or not ask for the medicine? What makes him believe that he should put the medicine on? What about wrestling? How do you ask questions about wrestling? Supposing the guy is wrestling with the child says he was wrestling with me, but he puts his hand and touches my wiener, and he squeezes it and tickles it. And you're like, oh man, that sounds like it's sexual. But I don't know. What would you want to know?
Is that, do you know if that's a wrestling move?
What were you wearing? You know, with this Greco-Roman wrestling? Or you're in,
Do you wrestle other times? Do you wrestle other times?
do you wrestle other times?
Yes, it's just...
Is this the first time? Do you wrestle other times? What were you wearing? Was someone else around? When do you wrestle? That's a good question. When do you wrestle? Whenever mom's shopping. Mom, you ever see him wrestle? They don't wrestle in front of me. There's a reason. Right? What did it feel like on your body? What time of day or night do you wrestle? Did you say something? If the child said, I don't do that, or it bothers me, or that's weird, leave me alone, and it happens again and again, and the child's able to communicate that, then you have perhaps a basis to go on. What about bath time? Bath time molests. Same thing. What about the context of the bath? Right.
Would this be leading though? Like, could you ask like,
Ask me a leading question. I'll make it unleading.
okay, could you ask, does he spend a lot of time washing his genital area?
Okay, what does he wash? What does he use to wash? Right? How long does he wash? Whatever she answers or he answers, right? But that's a good question. You're onto it. It's about context, right? Why not use a rag or one of those puffs? Or something else. Why not use something, a soft towel? Got to use your hands and your fingers? Why would a man, about context, about facts. Now, just because some dope uses their hands instead of, some dopey dad who's charging a kid who doesn't really know parenting well and is washing the child with his bare hands on her vagina, doesn't make it criminal yet. But I'm suspicious. Now, if he used a soft towel or whatever he used, it was an appropriate way or it seems to be appropriate, that's one thing. But every little bit, you know, is he totally nude? Or is he clothed? You know, that's an easy one. What was he wearing? And, you know, I say that, you know, as a joke and for some dramatic effect or not even comedic effect, if you want to call it that. But what he was wearing is an important question. He might go in there in his boxers. I want to know that. And they do. And you won't know unless you ask. Right? Context. What time of day is it? You know, if he wakes up the child to give her a bath, that's a problem, right? Back rubs, back massages. We get our fair share of back rub and back massage cases. Every now and then I call them coach dads. They go, oh, you know, she's a softball, she's an apple of my eye, she's going to be a pro one day. Oh. We had a few cases. Chris Fried had one that he tried, I think. I know he tried to play it out, but he's like, well, you know, I massaged her thigh, she had a Charlie horse. I mean, okay. You need to go there at 2 in the morning to massage his eyes? Context, time, what they said, how they acted, what they were wearing, where was mom? Has this happened more than once? The alternative hypotheses. Was it bathing or was it a molest? Was it horseplay or was it a molest? Was it wrestling or was it a molest? The problem is, and these cases are very, very appealing to jurors in the sense that... So anyway, that pretty much sums up Chapter 4, and that was about investigative interviewing. I want to pick up a little bit of Chapter 5, investigating suspected child abuse. Now, there was a video of a PowerPoint that I narrated that was among your readings, among your assignments, where I describe how to do an investigation of child maltreatment. And you can rest assured that there will be a number of questions on the examination from that PowerPoint. That's about investigative interviews and child maltreatment investigations. And it's about an hour long, and it's in Learning Module 5, I think, or 6. 5? Okay. So I just want to touch upon hearsay. Hearsay. Hearsay is a legal concept. It's something that lawyers worry about and judges make rulings about. But it's important for people who investigate crimes on children and investigate children who have been battered and exploited. It's important that they understand this legal concept. Because when you're out in the field and you're documenting what you learned, and you're writing down what witnesses said and how they said it, and what the environment is like in the homes that you visit, it's important for you to understand that there are certain statements that people make that may be admissible in court. Or they might not be admissible in court because of the way that the information came out. So if you understand hearsay, you can document the facts in the field in the way that makes it more likely that the DAG can get that information before the judge, or the prosecutor can get that information before the jury. Here's the definition of hearsay. So pay attention. It's a statement made outside the courtroom. Hearsay is a statement made outside the courtroom that's offered in the courtroom by a witness. Who is usually the person who didn't say the statement. So it's a statement that was made outside the courtroom, offered in the courtroom by a witness who didn't make the statement. To prove the truth of that statement. To prove the truth of that statement. And I'll break this down for you with examples. Hearsay is a statement made outside the courthouse that's offered in the courtroom by a witness who didn't make the statement. For the truth of the statement. That is, the reason why the witness is saying the statement is they want the judge and jury to believe that the statement's true. Statement made out of court that's offered in court by a witness who did not make the statement so that the judge believes it's true. Gabriella goes to Officer Bill Mott, who's the school resource officer at School 15. She has a relationship with him. She trusts him. She's 11 years old, and she tells Bill Mott, my uncle who moved in our home with mommy comes in my room at night and touches my titties. And I don't like it. Bill Mott, the school resource officer, is called by the DAG into family court. It's one of those emergent hearings. Orders to show cause. Initial review. What do you call those hearings? Order to show cause. What's the other term you guys use? Fact finding. Whatever it is, you're in a courtroom. Officer Bill Mott's on the witness stand. The school resource officer's on the witness stand. And he's about to tell the judge what Gabriella said about her Uncle Manny, we'll call him. Uncle Manny comes in my bedroom at night and touches my titties. Who's telling the judge what happened? Officer Mott. Who made the statement? The child, Gabriella. Is that an out-of-court statement? Yes. The statement was made over at School 15. It's offered in court. Out-of-court statement offered in court by Bill Mott, Officer Mott. In court. Did Bill Mott make the statement? No. It's a statement that he didn't make. The statement is made by someone other than the witness. And why are we bringing in Bill Mott to tell the judge this? Do we want the judge to conclude that Gabriella's had her breast fondled by Uncle Manny? Is that why we pulled him in? Yeah. We asked Bill Mott to come in, to take the witness stand and tell us what Gabriella said, so that the judge concludes that Gabriella's been fondled by Uncle Manny. So that's an example of an out-of-court statement offered in the courtroom for the truth of the matter.
So that's hearsay.
That's hearsay.
So all we do in court is hearsay. But you
Your
don't make the
court,
statement.
your proceedings are so crazy. There was a bit of controversy and a little bit of misunderstanding about how the process works on these orders to show cause, these fact findings, and similar proceedings that the division has all the time with DAGs. The DAGs tell me we don't have to follow the hearsay rules. And they may say it differently than that, but this stuff comes in all the time. In fact, I'm told there's a record of the case, and the judge takes the record of the case sometimes, big pile of papers. There is so much hearsay that the court relies upon in these proceedings that it's mind-boggling that it's permissible. But so the entire package of materials, that's all hearsay, right? A document is hearsay by definition, right? If something's written down, that statement is made in some other place. It's made on a piece of paper, its form is different. If you offer the document in court for the judge to read, that's an out-of-court statement offered in court because you want the judge to believe what's written down. There's no more pure form of hearsay than a document or a piece of paper. Police reports are hearsay, DIFAS reports are hearsay, hospital reports are hearsay. Now, there are 19,000. There are dozens of exceptions to hearsay that we're going to talk about next class. But that's hearsay. One of them is maybe Bill Mott's statement. There's an exception for kids under 12 we'll talk about next week. I made the kid 11. But let's make the kid 15. In a DIFUS fact-finding, Bill Mott will be able to testify. That doesn't make it any less hearsay. Now, the judges tell me, because Chris Fried and I are part of the group that's doing this child welfare project to train workers. His father's a family court judge. And other family court judges, they say, it's not really admissible, it's not, and I don't let it in all the time. But I hear otherwise, that the routine is that it comes in. And the DAGs tell me that that's okay, and that there's case law, and there's different rules that allow some of this to come in. Now, in order to show cause, I can appreciate that. That first initial hearing, the rules of evidence are not as formal and not as restrictive. But as you get down, as you move further along in the process of dealing with a family, these rules matter. And I challenge anybody, and I'll bring this up with the DAGs again, you can't tell me that in a proceeding for termination of parental rights, they allow hearsay. No good defense lawyer is going to let that happen, and I don't believe it's admissible. The rules of evidence have to apply in something as dramatic as termination of parental rights. Now, how many of those cases you get in your career? Not a lot, I imagine. Enough, but not a lot. First appearances, orders to show cause, initial, what do you call these? Initial fact findings. You get 20 of these a week, I guess.
But the fact finding is I think is...
Fact finding is whether it's substantiated or not?
Yes, and
whether they wind up on a central registry?
Yes.
Hearsay rules ought to be respected. Because that person, you know what the court said a few years back? You didn't have to have a full hearing on a fact finding. This case law is less than 10 years old, where the caregiver under Title IX is entitled to a full due process hearing now because of the consequences of substantiation. The caregiver who's under investigation by the division is entitled to a full, they call it trial-type hearing. I forget the name of the case. So in that proceeding, that fact-finding, the rules may be more liberal, but I think, generally speaking, the rules of hearsay ought to be respected. I don't think they are. In a TPR, I can't imagine them not being. And the reason is, not because I'm some guy who's interested in hearsay and just likes to use the word. Anne Boleyn was a victim of the grossest form of hearsay. Her whole prosecution in Henry's England was based on hearsay. There were stacks of documents used to convict her. Statements of people that she never met or never had the opportunity to cross-examine. Hearsay is by its nature unreliable. It's the word of someone else. I call it the best witness rule. One way to conceptualize hearsay is to say, okay, somebody made a statement in court about another statement. Somebody's on the witness stand telling us about what someone said. Are they the person who experienced this? Are they the best witness to tell us what happened? Is Officer Mott the best witness to tell us what Uncle Manny does? No. It's Gabriella. If Alp was coming up the parkway and he passed by that terrible accident by the Union Toll Plaza, and he told Teddy about what happened before class, and then Alp left early, and I said, Teddy, you tell me what happened. He'd be telling me what Alp told him. He wouldn't be the best witness. He could tell me what Alp told him. But he wasn't at the scene. He didn't experience it. He didn't drink it in with his senses. He's not the person who's best equipped to tell us about what happened. So hearsay is unreliable. There's no doubt about it. And the courts have spent 300 years defending the principle that hearsay is inadmissible. Having said that, there's dozens of exceptions to hearsay. Every one of those exceptions is based upon whether the statement is more reliable than the average statement. So if the touchstone, if the most significant aspect of keeping hearsay out is the fact that it's unreliable, that it can't be trusted, it's filtered through some other human, it's not the word of the person who experienced the event, thus it's unreliable. Sometimes hearsay statements are considered more reliable. Thus there's an exception. I'll give you one quick exception before we leave for today, just to show you, and we will revisit this again next Monday evening. Statements made to your doctor. Statements made to your doctor for purposes of medical treatment are considered an exception to the hearsay rule. A nurse or the doctor or the hospital social worker, generally speaking, can come in and say what the patient said in contemplation of getting treated. So, if I went to the doctor because I was having chest pains, and I said to the, very often, the paraprofessional comes out, right, or the nurse, asks you what's going on, how you feeling, doesn't matter who, all of the treatment team is the same when it comes to statements made to medical professionals. Could be the nurse or whomever, paraprofessional. You make the statement. So what's going on, though? So, I don't know. Every time I wake up in the morning, I got this pain in my chest, and it only happens when I jump out of bed quickly. Sometimes I just kind of slide out of bed smoothly. It doesn't hurt. When I jump out of bed quickly, I get this sharp pain. It goes into my shoulder, and I want the doctor to take a look at it. Well, the doctor will be about in 20 minutes. How you been? I haven't seen you in a long time. Have you gone over to the Great Notch over there? I hear they got a lot of motorcycles on Sunday. Yeah, I went over there. I saw a guy crash his motorcycle into the back of the Great Notch. No kidding. Yeah, but they pulled him out. He was pretty much okay, but his bike was all messed up. Okay, end of conversation. Statement about the motorcycle to the paraprofessional, to the nurse, or even to the doctor. Admissible? I'm telling a medical doctor's assistant or the medical doctor herself, is it admissible? No. No, why not? Yeah, it's not pertinent. It's not pertinent. I don't have an increased motive to tell the truth because I want to be treated and get better. When you have chest pains, you don't want to BS the doctor. You want to tell the doctor what's going on. If I had chest pain, yeah, my big toe hurts too. And when I twist my ankle, I get a radiating pain there. It doesn't really happen, but I felt like messing with it. Why would you do that? You want to get better. You don't want to die. The assumption is that you will give accurate treatment to your physician when you need to be treated. You're more likely to say things that are truthful, and that information is better recorded, and it is an exception to hearsay rule. The statement and chit-chat to the paraprofessional about the motorcycle that crashed into the, to the building at the Great Notch Inn on Route 46, that's not, I didn't make that statement in terms of wanting to get treated, so that would not be admissible, because there is no heightened reliability for a statement like that. We will look at a number of these that affect children next week, okay? So I'll see you all next week.